Hello. I'd like to talk with you a little bit about dealing with protests and appeals. This is one of the subject areas that we cover in this module of our class. Okay, just an overview of this short lecture. We'll talk about the types of protests and appeals, what we mean by those terms. Also, how can we prevent protests? How do we deal with a bid protest or a protest of an RFP? And also the question, should we include the protest procedures in our solicitation? How debriefing and public record requests can be part of a bid protest. And then finally, I want to share with you a case study of a bid protest from a few years ago, Western Bus Sales. Okay, first of all, what is a protest? It's really a complaint or an objection made to a governing body by an interested party, like a bidder, regarding a procurement decision. It's also a formal declaration of disapproval by a concerned party, including a statement of the resolution sought, or what we refer to as the remedy. For example, a bidder would say, I don't like your decision on selecting my competitor, and by the way, I would like you to give me the contract as the remedy. Now, some agencies use the term appeal for a bid protest. For example, when I worked for the regional government of Portland, Oregon, we use the term appeal for essentially a bid protest. We didn't really use the term protest. But for most agencies, an appeal is really the next level of challenge, maybe to a board of contract appeals after a bid protest is ruled upon by a chief of procurement. Really two basic types of protests that I'd like to share with you. The protest of the solicitation, specifications, or contract provisions, or what some refer to as a request for change. Now, this is during the time that the bid or the RFP is on the street, and there's a requirement that a potential vendor wants to challenge. The most common form of protest is really the protest of contractor selection. Essentially, you should have picked me is what the contractor that was unsuccessful is going to say. So why should we allow protest? Now, the public needs a process to question procurement activity. I think that's fair. Part of transparency, you could say. It does provide for checks and balances in the system, and it proves that the process is fair and objective. It can also demonstrate a high degree of integrity of the procurement process and of procurement professionals. And finally, the administrative process is less costly and less time-consuming, say, than the judicial system and a supplier going directly to court. Something that based on my experience, I hope we can avoid. Now, I want to share with you a quote from a colleague of mine, David Gregan, as past president of NASPO. Mr. Gregan says that protests to resolve honest, bona fide grievances are reasonable. Citizens should have a right of redress for any government activity. Now, Mr. Gregan has experience in the U.S. Air Force as well as chief of procurement for the state of Indiana and Washington, D.C. Great experience there. Okay, preventing protest. What can we do? First of all, let's ensure our selection criteria is clear and well stated. How are we going to award the bid or the RFP? And also that we follow the criteria in our solicitation, whether it's a method of selection for lowest responsible bidder or highest ranked proposer. We have the criteria on how we're going to select the winner very clear, and we follow it. I think that is just a great bit of advice for our profession. That we also use clear and concise requirements in our solicitation documents. Maybe a pre-bid or a pre-proposal conference can be included in your process, and that will help address questions that vendors have that may prevent a protest later. And also to allow solicitation protests that we discussed earlier. Now, something that can be addressed in a solicitation protest, maybe those are bid requirements or bid specifications. If a vendor elects not to file a protest or request for change, that usually cannot be brought up later when we're looking at an award decision protest. So, and also consider debriefing with your suppliers that aren't selected. We'll talk a little bit about that in just a couple of minutes. Okay, dealing with the bid protest. So make sure the protest is written and that it's timely. So if your agency has a rule on timely submission of protest, if that's 7 days, if that's 14 days after your contract decision, don't allow or consider late protests. At least that's my advice. And obviously, we want them in writing. An unhappy vendor that gives us a call might vent a little bit, but I don't consider that a protest. So be fair and objective in considering the merits of the protest and respond with factual information relative to the issues raised in the protest. I also suggest that we be polite, courteous, matter of fact, and don't take it personally. It's just part of our business. State your decision, inform the protester of their rights. If they have a right of appeal, say to your governing body or a board of appeals, they should know that. And I definitely encourage us to avoid being blindsided. For example, an unhappy vendor goes directly to your board of education at a public forum, and you don't know about it, they don't know about it, and you're blindsided. Not a good position. Okay, so should we include in our solicitation the protest requirements and protest procedures? Now, first of all, your agency may require that they be included in the solicitation. Certainly, I would follow that. Now, does it provide a roadmap for vendor protest? In a way, it does, but does it result in more specification protests? In my experience, I would say no, but I have colleagues that disagree with that. It does tell them how to do it right if they're going to protest. And I think it could also discourage frivolous protests or protests without real merit. And it can be helpful to your agency in responding to the protest. You can actually refer back to your RFP on when you respond to a protest. Now, debriefing, I think, can be a valuable tool. It's an opportunity for an unsuccessful vendor to meet with an agency, maybe the chief of procurement, maybe the department head of your fire department, if that's who you're buying with. I think that's a pretty good way to team up on a debriefing. It's an opportunity for them to better understand the contract decision. I was lowest bid, for example. Why didn't I win? And we can let them know, what price was one consideration, but it was the highest ranked proposer that was awarded the contract. That's just an example. But that type of information and education can often ward off a formal appeal. It's also the opportunity for a vendor to speak their mind if they're unhappy. Maybe that's really all they want, is to vent a little bit. Okay. But no, it does take additional time, so there is some downsides to debriefing. But again, I found it to be a valuable tool. Some benefits of debriefing. It can help us identify ways to improve our procurement process in the future. And hopefully that vendor who gets the debrief can be in a position to submit better bids or better proposals in the future. Maybe they see what a winning proposal looks like. It provides industry feedback to our user departments. That's another plus. And it also establishes a reputation of our agency being fair and open. Now, as I mentioned, public record requests can at times be a part of a bid protest. So these requests for information by bidders that are not selected, at least that's the most common instance. So obviously we want to know our laws and policies on providing records, on public records policy. Bids and proposals are often available as a matter of public record after award decisions have been made and announced, say through an intent to award process. So if I'm in the midst of evaluating bid submissions or proposal submissions, interested bidder said, hey, I want to see a copy of those, that's a little premature. So again, after the award decision has been made, that's when most agencies say they are available for public inspection. Now, remember, proprietary information and confidential information marked in a proposal should be redacted or not provided. And certainly during a bid protest or a public record request, you're going to want to engage your legal counsel. That's a powerful partnership when things get a little tough in the procurement process. Finally, I want to share a protest case study with you. It involves Western Bus Sales, and it was an invitation to bid issued several years ago by Portland Schools, one of my previous employers. And the bidder was not selected. They filed a bid protest contending that the lowest bidder was non-compliant. Now, the bid protest itself and the agency response from me are on your class page if you want to take a look at them. Now, please know this is not an assignment, but it may be of interest to take a look at a real-life bid protest. At least I hope it is. Okay, that's it for the lecture on bid protests. So there's my contact information if you have any questions or want to shoot me a note. Always great to hear from you. Thanks, and have a great week.